Are you an established small business owner or aspiring entrepreneur? Would you like professional advice to help your business grow and succeed? Well, look no further. The Virgin Islands Small Business Development Center is the territory's #1 resource to move your business forward. Enjoy no-cost advising, low-cost training, and technical assistance from experts in both the public and private sectors. The VISBDC is nationally accredited and sustained by the University of the Virgin Islands and the U.S. Small Business Administration. Visit us at our locations on St. Thomas, St. John, or St. Croix, and follow us on social media at VISBDC. For easy access to all our training and networking events, be sure to join our newsletter and download the VISBDC app. The Virgin Islands Small Business Development Center, here to help your business start, grow, and succeed.
Hello, good afternoon, everyone, and welcome to the VISBDC's hosting of the U.S. Patent and Trademark Office series, Trademark Basics webinar. This session educates the audience on what all entrepreneurs, small businesses, and startups should know about trademarks. Allow me to introduce today's lead presenter, Ms. Christina Calloway. Christina Calloway is an attorney for Trademarks Customer Outreach with the USPTO. She began her career at the USPTO as a trademark examining attorney, where she served on a team dedicated to reviewing sound and motion trademark applications. Ms. Calloway has collaborated with numerous local and national organizations, educational institutions, and businesses to educate small business owners and creators about intellectual property. Throughout her career, Ms. Calloway has sought to merge her personal passion for the arts and professional pursuits in public service and has been awarded recognition for her service and leadership professionally and personally. She is an executive board member of the Northern Virginia Fine Arts Association and served on the City of Alexandria's Commissions for the Arts. A proud Army brat, Ms. Calloway obtained her Juris Doctor degree from Howard University School of Law. Here's a friendly reminder to put your questions in the chat, and they will be addressed by the presenting team either directly in the chat or later during the question and answer segment. A copy of this presentation will be attached to the post-survey email that will be sent out directly after this session. We encourage you to take a few minutes after this training to fill out the survey that lets us know how we're doing. So without further ado, Attorney Calloway, the floor is yours.
Thank you so much for that introduction, and thank you all for joining us for this presentation about trademark basics. Again, I'm Christina Calloway, an attorney advisor in our Trademark Customer Outreach Office with the United States Patent and Trademark Office. So without further ado, we'll go ahead and get to talking about our agenda today, and then we'll get into the meat of today's presentation. Again, if you're just now joining us, if you have any questions, please feel free to drop them in the chat where they'll be answered by my colleague, or we'll also have a period at the end of today's presentation to discuss those questions as well. So today we're going to be talking about trademarks and the federal registration process with the United States Patent and Trademark Office. We're going to start first with some definitions about what intellectual property is, as well as what a trademark is, as well as the benefits of federal registration with the USPTO, how to select strong trademarks. You want that strong brand distinction and strong brand identity. Once you decide that you want to move forward with that application process, how to go through the filing and registration process, and then we'll discuss some resources that the USPTO has, free resources that the USPTO has to help you with the filing and registration of your trademark application. Okay, so without further ado, let's get started with our trademark fundamentals. So there are 4 different types of intellectual property, and we're talking about trademarks today. And intellectual property is just something that you are creating with your mind, and it can be protected by the federal government as far as trademarks are concerned. Trademarks are what you are using to indicate the source of your goods and/or services. So that could be terms, it could be letters, it could be phrases, it could be numbers, it could be a combination thereof, it could be design elements, color, or stylized font that you're using to indicate the source of your goods and services. So on my next slide, I'm going to show you some very well-known trademarks. The average consumer sees about 10,000 trademarks per day. And I want you to think about these particular marks, well-known trademarks, and think about what you connect these trademarks with when you see them. For example, when you see those arches, that M arches, even without the distinctive color that you may recognize it you normally with, the color yellow, you probably are thinking about hamburgers or French fries, or maybe those restaurant services that McDonald's has. When you see that half-bitten apple, you're probably connecting that with like smartphones or computers or the music streaming services that Apple provides. When you see that check mark, that Nike swoosh mark, you're probably thinking about footwear, right, in connection with that particular mark, or Coca-Cola with those carbonated soft drinks, or Amazon with their online retail store services. So you see how this is a combination of different types of trademarks that are in different stylized fonts, some have design elements, they're in different script, different shapes, etc., and they're being used to indicate the source of those goods and/or services. So we know that now we know that a trademark identifies the source of goods and services, but it also distinguishes your goods and/or services from those of a third party. So think about, for example, Coca-Cola and Pepsi. You may be a Pepsi lover or Pepsi drinker, or you might be like myself, that is a Coca-Cola drinker. I'm brand loyal to Coca-Cola. In essence, they're providing the same type of goods, right? Those carbonated soft drinks, but with those different trademarks that help us indicate that you want a Coca-Cola over a Pepsi or a Pepsi over a Coca-Cola. So you see how that trademark distinguishes one party's goods from those of another, even if they are the same or related types of goods. And a trademark also provides you with legal protection for your brand. So it provides you with that source indicating feature, also distinguishes your goods from goods and services from those of another party, as well as providing legal protection for your brand. So let's talk about what a trademark does not do. For example, it doesn't mean that you legally own a word or phrase. So you may have a phrase or word in your trademark, but that doesn't mean that you legally own it by getting a federal registration for that particular trademark. So let's use apple, for example, because that's a general word, right? It's a type of fruit. We have to be able to say it or call a fruit by its name. So apple does not legally own the word apple, but they do have exclusive rights to use it in connection to indicate the source of those smartphone goods, those computer goods, those music streaming services, etc. It doesn't mean that Apple can stop anyone from saying the word Apple, or that we have to owe them money every time we say the word Apple. Again, when you have a trademark, you're indicating the source of your goods and services, and a federal registration means that you now have the exclusive right to use it in connection with those goods and/or services. Let's go over a few quick definitions regarding trademark. Now, I use the word trademark interchangeably for goods and/or services. Most people do, but trademark normally indicates the source of goods and/or products, and then service mark indicates the source of services. But you can use the word trademark interchangeably for both, which is probably what I'll be doing during today's presentation. So when you have a trademark, or if you have a trademark, you probably don't call it a trademark. You probably say, I have a brand name, a logo, or a slogan that I'm using in connection with my brand or with my business or with my goods and/or services that you're providing. So those are our traditional types of trademarks, or our common source identifiers: brand names, logos, and slogans. So let's use Coca-Cola again for an example. Coca-Cola, it's the real thing. That's the slogan that they have. And we don't normally see it just in this typeface font, right? We normally see it with some type of special script or color, or there may be some design elements. Now, they do have registrations for just the terms or the wordings that we see here. But like I said, we normally see them with some type of design element, color, or that famous Coca-Cola script that we are all aware of. Coca-Cola also has a registration for the configuration of their product or the packaging for their goods, that Coca-Cola bottle shape. Even without that brand on the front of that Coca-Cola bottle, you are probably knowing that it is a Coca-Cola branded product. So that is a more non-traditional type of mark, which we'll discuss in just a second. So non-traditional types of marks, anything that functions as a source indicator, might be eligible for registration. So I just talked about that configuration or that bottle shape, right? So distinctive that a consumer or the public knows that that is a Coca-Cola branded product. So they have a registration for the configuration or shape of that bottle for their products. Think about sound. Those NBC chimes for those television broadcasting services, that type of sound. The voice of Darth Vader is a trademark for toys and related types of goods. So a sound can be used as a source indicator. Think about color, right? The red soles of Christian Louboutin footwear, or if you were to hand someone a box in that robin's egg blue, right? Even before they see the top of that box with the name Tiffany's on it, that color blue on that packaging is indicating the source of those particular jewelry goods. Okay, think about the brown on a UPS truck on those uniforms for those parcel delivery services. Scent and smell. Play-Doh has a registration for the scent of those clay molding goods. So even as an adult, or if you have children, you probably can recognize the very distinctive smell of Play-Doh when you open that packaging, that musky vanilla scent, and that is a registered trademark that Play-Doh has. Motion, if you think about before film starting, right? That roaring lion for Goldwyn Myers, that is a motion mark for those film production services, letting us know who is providing this particular film. Hologram, maybe on a trading card, baseball trading card, or on an American Express card, they have a hologram registration. And we talked about that configuration and shape of those Coca-Cola bottles. All right, so some quick knowledge checks now that we know what a trademark is. It is a type of intellectual property that indicates the source of goods, indoor services. We know what it does, what it does for you as a business owner, and then also we know what it does not do in different types of trademarks. So let's get into some knowledge checks. So here I'm going to be asking for a little interaction. You don't have to come off mute to interact. You can just drop your answers in the chat, and let's just see if you're getting. Make sure you're listening to me this afternoon. All right, so the first knowledge check is, does a federally registered trademark mean that you own a word or phrase? So does a federally registered trademark mean that you own a word or phrase? And I'm going to see if I can see if some of y'all are answering for me. Oh, yes, I see. Okay, great. I'm getting a lot of no's. So no, it only means that you have the exclusive right to use that word in connection with your goods and services. Doesn't mean that you own a word or phrase outright. In our next knowledge check, do you have to use your business name as your trademark? Think about that one. Do you have to use your business name as your trademark? And I'm looking in the chat. I'm seeing those answers coming in. Thank you so much for your participation. And right, I'm getting a lot of no's. No, you're not required to. You can, but you don't have to. Remember, a trademark is anything that you are using to indicate the source of your goods and or services. So as a business owner or a creative, you make the determination of whether or not you're using your business name as your trademark, or if you're not, maybe you have a business, but you're using something else as the trademark in connection with your goods and or services. Thank you. All right, so let's talk about the benefits of federal registration with the USPTO. So there are traditional ways of creating types of trademark rights. There's common law rights and as well as federal registration with the USPTO. In the United States and in our U.S. territories, the way that you receive trademark rights are by usage. You have to be using a trademark in connection with your goods and/or services in commerce, in the marketplace. So with common law rights, this is created as soon as you're using your trademark in connection with goods or services in the marketplace. So even if you come for a federal registration, you're not purchasing a trademark from the USPTO. It's something that you're already telling us that you have, and you're using it in connection with these goods or services that you're telling us. So as soon as you start using your trademark in connection with goods or services in the marketplace, you have a trademark and you have those common law rights. But common law rights are only limited to the geographic area where you're using that particular mark. So say, for example, you have a candle company and you are selling your candles at a local market every Saturday. You go out to the local market and you sell those candles with your trademark on them. So that's all well and fine, but you would only have those rights to protect that trademark in the geographic area where you are currently using that particular mark. But say, for example, someone comes and visits and they purchase your candles. They love this trademark. They think it's catchy. They think it's very strong. They go back to where they're from, maybe the state of California, or they're coming to Washington, go back to Washington, D.C., and they decide to use your trademark to sell candles. Well, you wouldn't have any rights against them for using that trademark because you only have those common law rights in the area that you're currently using them. When you have common law rights, you can use the letters TM next to your trademark for trademark or SM for service mark, but you wouldn't be able to use the R with a circle, which means a federally registered trademark. So if you want those broader rights, right, you don't want someone coming to purchase your candles, then going back to wherever they are from in the United States, and then using your trademark that you've worked on to sell those particular goods, then you need to consider federal registration rights. These are created when you federally register your trademark with the United States Patent and Trademark Office. One, it gives you the legal presumption that you own the trademark, and then it's going to broaden the scope of your rights in the United States and in our U.S. territories. It's also going to put the public on notice of those rights because now you have that federally registered trademark. And now you are able to use that R with a circle next to your trademark, meaning you have a federally registered trademark. Other rights that you have now that you have that federal registration are that you can bring legal action concerning your trademark in federal court. And you are required to do so if you have to bring a trademark infringement lawsuit against someone. You would need that U.S. registration. You are also able to record your registration with the U.S. Customs Border Protection so that they can prevent any infringing goods from being imported or exported. So think about goods that are normally knocked off or regularly copied and knocked off, right? Apparel goods, maybe electronic goods, software goods. You want to make sure that your trademark on those goods is not being infringed upon for lesser quality goods, etc. So you would be able to record that U.S. registration with U.S. Customs and Border Protection to provide you with those types of protection. As well as you can use your U.S. registration as a filing basis in another country. So once you receive a federal registration, you are only receiving rights in the United States and across our U.S. territories, okay? There's no such thing as an international trademark rights or trademark registration or worldwide trademark registration. So you have to get a registration for trademark rights in every country that you want those rights outside of the U.S. and the U.S. territories. So say, for example, you have goods that you sell in the U.S. and in the U.S. territories, but you are manufacturing your products in another country. So you may consider getting those rights in another country for that protection there where their products are being made, and you can use your U.S. registration as a filing basis to do so. All right, so the symbols that you can now use, like I mentioned, that are with a circle, you're permitted to, you're not required to, but you are permitted to do so. And it's now unnecessary for you to use that TM for trademark or SM for service mark next to your marks, okay? So again, you have those two different rights you established by usage, those common law rights that are just limited to the geographic area where you have those, where you're using that mark, and then those federal registration rights that broaden the scope of your rights. You are not required to get a federal registration for your trademark. That's a decision that you make as a business owner, as a creative, as an entrepreneur regarding your intellectual property. But as you can see here, the rights that will be extended to you once you receive that federal registration. Okay, let's do some quick knowledge checks again, now that we've talked about those benefits. Are you required to register your trademark with the USPTO? Are you required to register your trademark with the USPTO? And you can just drop your answers in the chat. I see them coming in. Thank you so much for your participation. And the answer here is no. Federal registration is a choice. That's a choice that you're making as an entrepreneur, as a creative. Many trademark owners apply for federal registration. However, because of those nationwide rights that they're going to receive for that once they get that federal registration. Okay, does registering your trademark with the USPTO give you international protection? Does it provide you with worldwide or international trademark protection? And I'm seeing those answers coming in. Yes, and the answer here is no, right? Registering your trademark with the USPTO is only going to give you protection in those 50 states, in our 50 states, in the US territories. You are able to use your US registration as a filing basis in other countries. So we know what different types of trademarks we have. We know about the benefits of federal registration with the USPTO. Let's get into a little bit of the creativity part of how to select a trademark, or what you should be considering when you're selecting one, or if you already have one, to ensure that you have a strong trademark. All right, so remember that the mission of the USPTO is to register any trademark that is eligible for registration. Our goal and our mission is not to refuse trademark registrations. We want you to have those trademarks registered with the federal government, with the federal agency. But the mission here is that it has to be eligible for registration. So one, not every trademark is going to be eligible for registration. And two, not every trademark is going to be enforceable. So when you're selecting a trademark, creating your trademark, or if you currently already have one, you want to be thinking about a trademark that is both federally registrable, it's going to go through the registration process, as well as legally protectable by that registration. There are two main concepts to think about when you're thinking about that being registrable as well as legally enforceable. First is likelihood of confusion. This is the most common refusal that applicants receive once they file that application. Likelihood of confusion is where we're looking at or making sure that there is no confusion in the marketplace between your mark for certain goods and services and another party's mark for other goods and services. Remember that trademark is going to distinguish your goods and services from a third party. So we want to make sure that doesn't happen with a federal trademark that is already registered. And then another concept is the strength of your trademark. Another common refusal is a descriptiveness refusal. And when you're just providing us with information about the goods and or services, describing what the goods and services are, but your trademark doesn't really indicate the source of those particular goods and services. Let's talk about a little bit more in depth about that most common refusal, the analysis that you need to be considering and doing some homework before you are applying to register your trademark. That is that likelihood of confusion. Here we want to avoid confusing consumers about the source of goods and services. Remember, we want to be able to distinguish the source of goods and services with the trademarks. So this is the test that the examining attorney is going to be using when analyzing your application once you file it, but it's also the test that you can use in doing homework prior to filing your application, right? Because you want to make sure it's going to go through that registration process and do a little bit of homework. Also, you pay fees to file those applications, so you want to make sure that your fee is going to pay for the application to go through, right? It does not, you're not going to get a refund if your application does not move forward, your trademark does not move forward to registration. So the test is, the first prong of the test is that we want to make sure that the trademarks, we're looking at whether the trademarks are confusingly similar. We're looking at whether the marks look alike, sound alike, whether they have a same meaning or connotation or a similar commercial impression. So that's the first prong of the test. The second prong is we're going to be looking at whether the goods and or services are related. not just identical goods and services, but whether they are related, okay? So whether the marks are confusingly similar, whether the goods and services are related. If you're meeting both of those prongs, or if your application upon review is meeting both of those prongs, you are most likely going to receive a likelihood of confusion refusal. So you may be thinking to yourself, okay, if I don't meet both of those prongs, I'm going to be fine, right? You can have marks that are identical or confusingly similar, and they could possibly have goods and services that are not related. Think, for example, about Delta for faucets and Delta for air transportation services, right? Identical marks, they are confusingly similar, but the goods and services are not related, right? Consumers are not thinking that they're going to the same brand for faucets, for a sink, and then their air transportation services, right? So those registrations are able to coexist in our database. So let's do some examples going through that particular analysis that you can do, as well as what the examining attorney is going to do when they're reviewing your application. All right. So first, the application that's coming in, or your application, is T-Markey for shirts. And then the registration, once we do a search in our USPTO database for federally registered trademarks, comes up with T-Markey for pants, okay? So we have T-Markey for shirts, T-Markey for pants. Let's do our analysis. Are the marks confusingly similar? And I'm happy if you want to participate in the chat. Are the marks confusingly similar? Do they look alike? Do they sound alike? Do they have the same meaning and connotation? I would say here, yes, right? They are identical, so they look and sound alike. And then shirts and pants, are those goods related? Are consumers used to seeing a company provide both shirts and pants under the same marks, right? Yes, right? So in this particular case, this would result in a refusal, a likelihood of confusion refusal. The marks are identical, they look and sound the same, and then the goods are related. Okay, let's do another example. Your trademark again is T-Markey for pants, and then the registered trademark is T-Markey for pants. Yours is T-Markey for shirts, and then T-Markey for pants is the registered trademark. Okay, so as the examining attorney, would you allow this to move forward to registration? Let's look at our analysis. Are the marks confusingly similar? Do they look alike? No, they're spelled differently. Do they sound alike? T-Markey and T-Markey. Yes, I pronounced them in the same way, so they sound alike. And then we know from our prior example that shirts and pants, consumers are used to seeing these sold by the same entity or same brand. Let's do one more example, and we're looking at changing the goods a little bit, okay? Looking for people who may play golf out there. T-Markey for shirts is the application, and then T-Markey for golf flags is the registered mark. Okay, let's do our analysis. Are the marks confusingly similar? Well, we know from our last example that yes, they are confusingly similar because they sound the same. They don't look alike, but they do sound alike. And then our shirts and golf flags, are consumers used to seeing these goods sold by the same brand under the same mark? Okay, so this might probably not be refused if we don't know if shirts and golf flags are sold by the same company under the same entity. Possibly could be refused if we're doing marketplace research, and that's what the examining attorney would do to see, hey, does Callaway Golf provide shirts and golf flags under that same under the Callaway Golf name brand? We're going to look into the marketplace to see if that is actually occurring in the marketplace. So you're doing a little research to make that determination. So it's the same type of research you can do as well when you're conducting a search in our database, and you want to do that search prior to applying and use that analysis of likelihood of confusion. So you're not required to use an attorney to file an application with the United States Patent and Trademark Office. We recommend using an attorney, but we provide resources for you to file an application if you decide to do so on your own. And if you do decide to do so on your own, you want to conduct that clearance search prior to filing the application and paying those fees. So a clearance search is going to consist of you looking in our USPTO database for federally applied for applications as well as registered trademarks. Okay, this is at uspto.gov. It's our USPTO trademark search system that you are able to access 24/7 on our website. So this is the research you'll be doing prior to filing that application. You also want to look on the internet for common law usage, right? Because an entity may not have filed for that federal registration, but they may have common law rights in the same geographic area or in a particular geographic area. So you want to be looking on the internet as well to see if someone is using a confusingly similar trademark without those common law rights. Now, if you hire an attorney or choose to work with an attorney, make sure you're hiring an experienced trademark attorney, not just any attorney. And they would also be conducting a comprehensive clearance search. They're going to look in that USPTO database. They're going to check state trademark databases, business name registries, foreign trademark databases, as well as the internet. So they'd be doing a complete and comprehensive search prior to filing an application on your behalf. All right, so now we know about that most common refusal and the analysis that the office is going to be using, the same analysis that you're going to use prior to when you're doing your homework prior to filing your application. Let's do one more quick knowledge check with that analysis. All right, so your trademark is X-Seed for agricultural seeds, and then the registered trademark that you find in the database is X-Seed for live plants. Let's do our analysis. Are the marks confusingly similar? X-Seed and X-Seed don't look alike here, but they do sound alike, right? We're looking for sound, appearance, meaning and connotation, commercial impression. And then are the goods related? Would a public consumer be used to seeing agricultural seeds and live plants sold by the same brand under the same mark? More than likely, yes. So this would result in a refusal under likelihood of confusion. All right, so let's talk about that other analysis you want to think about as well when selecting your trademark for descriptiveness refusals, the strength of your trademark. And this is very important because you want a strong mark that has strong brand distinction, right? To distinguish your mark from a third party's. It has economic value. You want people to come to your brand and be familiar and have that brand loyalism to your brand. So the concept here is that you want to avoid using trademarks that fail to indicate the source of goods and services, not just describing the goods and services. So the test here is we're going to be looking at, does this mark just merely describe the goods and or services? We like to use a temperature gauge to kind of make that determination of whether the mark is descriptive or if it's weak or whether it's a stronger mark. Okay, so we use this little graphic here to show weak marks, our generic or descriptive marks, and then as we're getting warmer or hotter to our strongest marks, they are either suggestive, arbitrary, or fanciful, and we'll go over each briefly. So generic marks or generic terms are your common everyday name for goods and services, right? So if you come in for a trademark that is the actual name for the goods that you have in your application, that's going to be generic, right? It's unregistrable. Everybody else has to be able to use that particular word or term or phrase, etc., for those particular goods and or services. So for example, milk for a dairy-based beverage. That is what milk is. That is what we call milk. So that would not indicate the source of those particular goods. Descriptive marks directly describe something about your goods and or services. So they're telling us something about the purpose, function, a characteristic about the goods and services, maybe the ingredients, something about the quality. They're just describing something about the goods and or services. And these are normally unregistrable marks. Now, you can sometimes provide us with a showing of acquired distinctiveness for descriptive marks. That means you have to show us with evidence that this mark, even though descriptive, has become so distinctive with your goods and or services that consumers would see it and recognize it as a brand or the source indicator for your goods and or services. It takes a lot of evidence to be able to show acquired distinctiveness. So normally these particular marks are unregistrable at the USPTO. So for example, creamy whip for whip topping. Right? Whip describes the type of goods, right? Whip topping. And then creamy is just telling us a characteristic about those particular goods. They're not really telling us, this mark doesn't really tell us who the source of those goods are. So now we're moving up on that temperature gauge. We're right in the center here, a little warmer with suggestive trademarks. These merely suggest something about the quality of the goods, indoor services. They don't just describe something. It takes an extra step for the consumer to think about the goods, indoor services. So these are normally registrable. Think about copper tone for suntan lotion, right? They don't really describe something directly about the goods, but it kind of suggests something about maybe the color of your skin once you put it on or something of that nature, but it's not directly describing. Fanciful marks are strongest types of marks along with arbitrary, but fanciful marks are invented words that have no meaning in any language. Something that you've just created doesn't have any meaning. These are strong, very registrable. For example, Xerox for photocopiers, or Kodak for cameras, or Kleenex for facial tissue, right? These are very well-known brand names. They have a huge brand distinction, but in actuality, the words don't mean anything. They're registered trademarks that are invented words that don't have any meaning. And then our other very strong marks are arbitrary marks. These are actual words that have no association with the goods, and/or services. These are very registrable or highly registrable. Think about Apple. We use that Apple example, Apple for computers, or BlackBerry for smartphones, or Gap for retail store services. These are actual words, but they don't mean anything in connection with those goods, and/or services. Okay, so now we know about the strength of a trademark. We want to make sure to avoid that descriptiveness refusals. We want strong marks for that strong brand identity and brand distinction. So generic and descriptive marks are weak, suggestive, arbitrary, and fanciful marks are stronger trademarks. Let's do a quick knowledge check with those concepts in mind. Which is more registrable, or which is going to be registrable? Put 1 in the chat for bicycle for bicycles, and then put a 2 in the chat for bicycle for playing cards. Which one would be able to be registrable? Okay, and I'm seeing answers coming in. And the answer here is going to be number 2, that bicycle for playing cards. Bicycle for bicycles is generic, right? That's what we call a bicycle. So that wouldn't indicate the source of those goods. But bicycle for playing cards, which is a registered trademark, is an actual word, but it is an arbitrary word for playing cards. All right, so now we've gotten through the analysis that you're going to be using, the types of trademarks, those benefits of federal registration. You're here today because you want to find out about filing and registration and what you need in order to do so and get those benefits of protection. So this is a very linear graph of how the process is going to go for you. I'm happy to answer any questions at the end about this particular process. So first, you would be filing your application with the USPTO. It's going to be reviewed by a trademark examining attorney at the office. It will then move to, if there are no issues, it's going to move to publication. That's where we're putting the public on notice for 30 days that this trademark is moving forward to registration. And then if there's no opposition, or even if there is and it is not upheld by the trademark examining attorney, your application is going to move forward to registration. How do you go through that process? You're going to be filing with us online at uspto.gov. It's going to be an electronic filing. There's no paper filing for trademark applications. You have 2 filing options. That's TEAS Plus at $250 per international class, and then TEAS Standard at $350 per international class. And just really quickly, international classes do not refer to international or worldwide trademark rights, right? We know that doesn't exist. International classes means the identifications of the goods and/or services that you have to put in your application that are in connection with your trademark. Okay, so this is just the categorization of these particular goods and/or services that was made by the World Intellectual Property Organization, and that's why it's called international classes. Now, with TEAS Plus, you see there's a difference in the filing fees. With TEAS Plus, $250 per international class, we're asking you to provide us with more information up front, which makes it a little easier for the trademark examining attorney to review. So we're passing off that discount to you. And that normally means that you are choosing something out of our trademark identification manual that has already been accepted by the USPTO, so that when they're reviewing that, they already know that it's in the manual and that it's okay to move forward as far as the identification. Now, say you have goods and/or services that you just want to write in yourself, or something inventive or innovative that hasn't been accepted yet, and that you actually do have to write in the application. That $100 is being passed back off to you for that review, and then it's $350 per international class. Now, you're not going to have to do any calculations in the system. Once you're filing electronically, that is going to be tallied up based upon however many classes you put in your application. So you don't have to do any math. That's a breather for me because I'm not too good at math. All right, so let's talk about our application requirements. First, when you're filing your application, you got to let us know what the trademark is. That's what we mean by drawing. You're providing us with a clear drawing of the application. You're not actually drawing out something in the application. You're just letting us know what your trademark is. So whether that is just the wording, or if it is graphic design elements, color, stylized font, you're uploading a picture of those particular of your trademark. You're going to tell us what your goods and services are used with that particular trademark. You're going to tell us your filing basis for the application, and that is the legal reason why you are able to file this application. So just really quickly, two most common filing bases are 1A, that's use in commerce. You already have a trademark that you're currently using in commerce, and you're filing to get that registration. Remember, our U.S. trademark rights are based upon use. You have to be using it in commerce. The second most common filing basis is a 1B, or intent to use filing basis. So say you are creating a business, starting your business, you have a trademark that you're working on, but you're not currently using it in commerce, but you will be doing so within 3 to 4 years. You can go ahead and file that application. You don't get protections, but filing that application helps prevent someone from coming behind you and filing a confusingly similar mark after your filing. Okay, so once you start to use that mark in commerce, you're going to pay an additional fee to change it to that 1A filing basis, use in commerce, and then it will move forward to registration. You're going to provide us with your contact information and then your corresponding filing fees with your application. So the most common refusals once you file that application is going to be reviewed by a trademark examining attorney. We've already talked about those most common refusals with the likelihood of confusion, merely descriptive. You have done some work prior to applying, so hopefully you've caught anything that could possibly be an issue. Other types of refusals are geographically descriptive. That is where you're just telling us something about the origin of the goods and services. You're not indicating the source of those goods and services. You can also receive what is called a specimen refusal. When you file your application for registration, you're going to show us that you're using the trademark in connection with those goods and services. A specimen is evidence that you are using your trademark in connection with the goods and/or services that you've listed in your application. So if the specimen does not support that, you'll receive a refusal and we'll ask for an additional or another specimen to show that. And then another type of refusal is an ornamental refusal, meaning that you may have a trademark word or phrase that you are using, say, on apparel goods or on the front of a hat or on a mug, and it's just emblazoned on the front of the hat or emblazoned across the front of the mug. Well, this is just showing the mark in a decorative manner. It doesn't really show it in a source indicating manner. We want to see more of hang tags or labels or that trademark on your online website to purchase those particular goods. Once you receive that examination, it's reviewed by the attorney, it goes through public notice, and you receive your registration, you are responsible for enforcing your trademark rights. The USPTO does not have any enforcement responsibility or abilities for that matter. But you may use your registration to send someone a cease and desist letter if you see that they are possibly infringing upon your mark, or you are able to use it to sue against an infringing user. Once you file that receive that registration, you are required to file post-registration documents with the USPTO. You have to maintain your registration. So you can have your registration in perpetuity as long as you are maintaining it with the USPTO. So think about within the first and fifth and sixth years, you have to let us know those post-registration documents. Then between the 9th and 10th years, and every 10 years after that. So you can have it as long as your business entity past your own life, as long as that is being maintained with the USPTO. Let's do our last 2 quick knowledge checks. I'm going to go over our resources really quickly so that we can get to our questions in our last 15 minutes. Are you guaranteed registration of your trademark? When you file an application with the USPTO, is it guaranteed that you are going to receive a registration? And I'm seeing those answers coming in, right? The answer is no, because every application is going to be reviewed. We talked about some issues such as likelihood of confusion or descriptiveness. So it's going to be examined before we have to make sure you have those application requirements. So that doesn't mean it's guaranteed just because you apply. And if your trademark registers, do you have to do anything to keep it alive? Do you have to let the provide anything to the USPTO to continue to maintain your registration? And I'm getting all of those yeses, right? Yes, you must continue to use your mark in commerce, and you'll be letting the USPTO know that as far as your registration. Okay, let's quickly go through our resources. I want to make you aware of scams, being aware of filing firms, as well as misleading or fraudulent communications. Okay, so when you file an application with the USPTO, it is public record. Has to be so that others can see these particular marks in connection with the goods or services to make sure that there is no likelihood of confusion. But since those are public record, you may be contacted. You may be contacted legitimately by attorneys that are seeking your business, but you may be contacted by those who are attempting to scam you, most likely out of money. So if someone calls you or sends you an email and says, we can guarantee your registration if you pay us this fee, then you already know, hey, that's not true, because I know that just by filing an application doesn't mean there's a guarantee of registration. So beware of those types of scams, especially if they're asking for monies. The USPTO would not be calling you requesting money. Your trademark examining attorney is not going to be calling you and directly asking you for any type of money. You're paying fees only through our electronic portal, so no one would be calling or sending you an email asking for money. Beware of filing firms. If you're using a filing firm can file your application for you. They cannot represent you in front of the USPTO. So if you're working with a filing firm, just be clear of whether or not they have an attorney on staff or not to actually respond if you get an office action from the office. So our hub is always going to be uspto.gov. There is where you will find videos from an attorney like myself with Trademarks Customer Outreach about all aspects of the federal registration process, as well as our Trademark Basics Registration Toolkit. You can go to that link or scan the QR code here. It's going to provide you with more concise information about the process, as well as tell you information about our Trademark Basics Bootcamp. On the next slide, I'm just going to provide you with the quick information about Trademark Basics Bootcamp. That is an 8-week series that you can participate in virtually, where an attorney from my office is providing live webinars about each aspect of the federal registration process, from what a trademark is to how to actually file your application. That is all free to you. You can go to this website, sign up. You don't have to attend all eight of the sessions. It just depends on where you are in your journey, and you are able to ask us questions live while we're going through that subject matter as well. Providing a link for our IP identifier, our free resources, as well as our virtual assistant on our website. Our IP identifier is going to let you know what types of intellectual property you have. So as a business owner, as an entrepreneur, you may say, hey, I don't know what type of intellectual property I have. I don't know if I have trademark or copyright or patent or trade secret. I need to know. So this is where you can go to take a 6-question questionnaire, and they're going to provide you with information about the types of intellectual property you might have and where to go to get those protections. Our Trademark Assistance Center, this is the telephone number, as well as the email address for any questions that you have regarding the process. They cannot provide legal advice, but can provide you with information regarding the process. Available Monday through Friday, 8:30 a.m. to 8 p.m. Eastern Time. The USPTO does not provide legal advice. We don't enforce those registration rights, and we cannot recommend specific private attorneys. We do have our law school certification program where you can ask questions specifically, where you can work with a law school that may be in your area, or if they accept clients virtually, to contact them for assistance. These are law students that are working underneath an attorney professor, working on applications for free or low reduced fee legal services. And with that, we're now at the question portion. I'm going to stop sharing and see if we have any questions from anyone here today. Thank you so much for participating. And I'll also check the box to see. Here, I'm gonna stop sharing. All right.
So we have a question. Is examination always done by an attorney?
Yes, so examination is always going to be done by a trademark examining attorney. Prior to my position in my Trademarks Customer Outreach, I was a trademark examining attorney. So when you file an application, there's always going to be an attorney that's going to be reviewing the application. They are not your attorney, they're the attorney for your application, but they cannot provide you with legal advice. They don't work on your behalf as far as helping you with arguments if you receive like a likelihood of confusion refusal. You can work with them, but they would not be able to provide you with legal advice.
Thank you for that answer.
Yes.
There's one more question. I have a trademark symbol from years ago, still in force and active. And I was to update the graphic. What is involved?
Okay, so if
And
you
I
already,
want-
oh, I'm sorry. Oh, if you already have a trademark that you already have registered and say it's just wording, or you already have a trademark, whether it was a logo, a brand name, etc. If it is something that if it's another type of trademark that you're using in the connection with the same goods and services, you would have to file another application. So you would not be able to add that to the registration that you may already currently have. So you would just file another application to receive another registration. You can have as many registrations as you need, right? Think about Coca-Cola or Disney or Apple. They have several registrations. So your business could have several registrations. You would just have to file another application. Same process you would have done the first time.
Here's another question.
Okay.
How long does it take to get your trademark registered?
Okay, right now, if you go online, we do have these dates and times online under our trademarks heading. Once you file an application, it takes about 7 months for it to be pulled and reviewed by a trademark examining attorney. Right now, the whole entire process through into registration can be 14 months. Okay. Again, that is depending on where you are in that linear graph that I showed. If there are any other issues, it could be longer, could possibly be shorter. Right now, the estimate is about 14 months.
Alluding to the previous question, same services, just updated the trademark logo before to the logo now.
So if it is a material alteration, if it's different, if there are different elements, if it's something that's going to have a different commercial impression, you would not be able to change that registration. You would have to file a new application. So that's the analysis that we would be looking at. So say you do have your current registration and you're changing some element of the trademark that you have in that registration. If it is a material alteration or amendment to that particular mark in the registration, then you would not be able to do so. You just have to file another application for the updated logo.
Okay, so one more question.
Okay.
So you let the old one expire while you have a new one for the updated logo?
That's a decision that you can make. If you're still using the old one, then you would continue to maintain it. But if you could go through a process to cancel your previous registration, or you could let it expire, whichever you choose to do as the business owner. So you would make that determination if you're like, I'm not going to be using that one anymore. Because remember, in order to maintain it, you would have to show us that you're still currently using it. Any other questions?
I think that's it. We see a comment saying thank you. Oh, no, one more. How long does it take to cancel a registration?
So that I don't know off the top of my head. It is a process that you give or provide with the petition to our office. So if you go to USPTO.gov, trademarks, petitions, there's where you would find more information about canceling your registration. I will just note, if it's the same attendee that's asking about updating their logo, you don't have to wait to get that to file your additional registration. Like, you don't have to wait for the old one to expire or be canceled in order to file your new one. You could go ahead and do it, be doing those processes simultaneously, whatever you choose to do.
And that's all I see for questions.
Okay, any other questions? I think we have about 5 minutes. Anyone else?
No, thank you. Good
All right.
information. It's coming.
Thank you, and thank you so much to the attendees for your participation.
All right, so if we can just go to that closeout slide. Just like everyone here in attendance to know that the VISBDC has so much more in store for USVI small businesses. You can visit our website at www.visbdc.org. Download the VISBDC app on your mobile device from the appropriate app store. Like and follow us on Facebook, Instagram, Twitter, Google Business, and subscribe to the VISBDC YouTube channel for new uploads of our on-demand webinars. Here's a preview of our upcoming trainings. Tomorrow we have the American Red Cross, and they're going to be presenting the business approach to when a disaster strikes in the USVI. And we have our USPTO team back again on the 28th. They're going to be presenting maintaining your federal trademark registration. On the 29th, we have Safety in Paradise. They'll be presenting safety and health practices for USVI businesses, and they'll be concentrating on disaster preparedness as well. And back on September 4th, we have the USPTO returning, and they're going to be presenting and learning about US design patents. So once again, we thank everyone who's in attendance for your time. Here's a friendly reminder that we're going to send out that post survey email, and it's going to include a copy of today's presentation. So on behalf of the VISBDC network, we thank the USPTO for their resources and their time to collaborate with us on this initiative. We wish everyone a productive rest of the day.